Okay, so if you've ever lived under the watchful eye of a homeowners association, you know that relationship can get, well, a little complicated. You pay your dues, you follow the rules, but what happens when you get that nagging feeling that your HOA is hiding something? You ask for some simple information and all you get back is silence? Well, today we're diving headfirst into a real-life legal showdown between a homeowner and his HOA to figure out what secrets they're actually allowed to keep. So let's just get right to it. Here's the big question. Is your HOA legally allowed to keep secrets from you? Now, your first instinct is probably to say, no way, I'm a paying member, I have a right to see everything. But as we're about to find out, the law is way more complicated than a simple yes or no. This is going to get interesting. All right, let's meet the main character in our story, John Sellers. He's a homeowner in Arizona who was absolutely convinced his HOA was breaking the law. He felt they were hiding crucial documents from him, and he wasn't going to let it go. So he took them to court to try and force them to show their cards. And he wasn't just asking for one thing. He came with a list of 4 very, very specific demands. And listen, these were not your average requests for landscaping budgets or pool maintenance schedules. Oh no, this was personal. He wanted every single email between the HOA's lawyers and his ex-wife. He wanted to see the uncensored legal bills for his own case against them. He wanted the secret minutes from all their closed-door meetings. And maybe the craziest one, he wanted all the chatter about a petition that his own neighbors had started against him. You can just feel the drama here, right? This was way more than a records dispute. But, there are always 2 sides to every story. The HOA had a very different take on the situation. Their president, a guy named Jeff Kaplan, came forward to defend the association. And, well, his version of events paints a picture of a long and pretty exhausting history with Mr. Sellers. And to give you an idea of what he meant by exhausting, get this. The HOA president testified that they'd received over 400 emails from Mr. Sellers in just 3 years. 100 of those were formal records requests. So the HOA's argument was basically, look, we've given this guy everything we're legally supposed to and then some. We're trying to be transparent, but this is just a lot. And this little chart right here just lays out the whole conflict perfectly. You can see the back and forth. When it came to the stuff about his ex-wife and that neighbor petition, the HOA's answer was simple. Sorry, those records don't exist. But for the legal bills and the private meeting minutes, their answer was different. They said, sure, we gave you the documents, but we blacked out a bunch of stuff because it's protected by attorney-client privilege. So there's the battleground, 2 flat-out denials, and 2 claims of legal privilege. So you're probably wondering, why on earth were his neighbors signing petitions against him? Well, the HOA president did not mince words. He testified that the petition started because, straight up, residents were unhappy with Mr. Sellers and they just didn't want him living there anymore. It gets even crazier. They apparently even showed up to his divorce proceedings to try and convince the judge to give the house to his ex-wife. I mean, wow, that adds a whole new level to this neighborhood feud. Okay, so we've heard from the angry homeowner, we've heard from the fed-up HOA. It's a classic he said, she said. So, who's right? To figure that out, the judge had to look at the rule book, the actual law. So let's hit pause on the drama for a second and look at the Arizona law that controls this entire situation. So the law really tries to play mediator here. On the one hand, it says, yes, homeowners have a right to see all financial and other records, and the HOA's got 10 business days to hand them over. But, and believe me, this is a huge but, the law also gives the HOA an escape hatch. It says they can withhold or black out information that's considered privileged. We're talking about private conversations with their lawyer, documents about ongoing lawsuits, and yeah, the minutes from those secret closed-door meetings. So the big takeaway here is that your right to see everything is not absolute. There are limits. And there's one more super important legal idea we gotta get, the burden of proof. Put simply, it means that whoever makes the accusation has to be the one to prove it. So it wasn't the HOA's job to prove the documents didn't exist. Nope. The pressure was all on Mr. Sellers to prove that they did exist and that the HOA was illegally hiding them from him. He literally had to convince the judge that his story was more likely true than the HOA's story. That's a high bar. All right, the stage is set. We've got the accusations, we've got the defense, and we know the rules of the game. So what happened? How did the judge rule? Did Mr. Sellers finally get his hands on those secret documents he was so sure existed? Let's get to the verdict. Well, the judge broke it down piece by piece, and it was a total victory for the HOA. First, on those supposedly missing emails about the ex-wife and the neighbors, the judge said Mr. Sellers just didn't prove they ever existed. Remember that burden of proof? He didn't meet it. Second, for the blacked out meeting minutes and legal bills, the judge said, yep, the HOA was perfectly within its rights to do that. It was privileged information. And the final nail in the coffin? The judge pointed out that Mr. Sellers actually admitted during the hearing that he was fine with what the HOA eventually gave him for the legal invoices. So the final decision? Case dismissed. And here it is, the official legal conclusion that ties it all together. The judge ruled that the homeowner failed to establish his case by a preponderance of the evidence. That's just the fancy legal way of saying he couldn't prove his claims were more likely true than not. The burden of proof was his to carry, and he just didn't have the evidence to get there. So, what can we all learn from this messy neighborhood saga? I mean, John Sellers' battle with his HOA gives us some really valuable lessons that any of us could use if we ever find ourselves in a similar fight. So let's break down the key takeaways.
Okay, here are the 4 big lessons to remember. Number 1, yes, you have a right to see HOA records, but that right has very clear limits. You need to know the exceptions. 2, if you end up in court, the burden of proof is on you. You can't just have a hunch that documents exist, you have to bring proof. 3, this sounds super obvious, but it's crucial. An HOA cannot give you documents that it doesn't have. And 4, never underestimate attorney-client privilege. It is a powerful shield that HOAs can and absolutely will use to protect their legal stuff.
And that brings us to our last question, for you to chew on. This whole case proves that taking on your HOA is a tough uphill battle. It takes real evidence, you've got to understand the law, and you need a clear strategy. So now that you know the rules of the game a little better, how would you handle a conflict with your own HOA? What would it take for you to say, okay, that's it, we're going to court?